I would encourage both sides to over disclose those opinions in caution rather than under disclose. I don't want to spend half our day at trial with me saying, where's that disclosed at? And then chasing the jury out while you dig through your thousands of pages trying to find where that is. I don't know whether we're going to have a Franks hearing or not.
In the Kohberger case, little tidbits of evidence are leaking out, but does that mean the case might open up anytime soon?
Could it be that Andrew was right, that with a new court is new rules and new openness potentially? I'm Lainey Law.
And I'm attorney Andrew Myers.
And does it look like things are finally starting to change in the Kohberger case?
Well, I don't know. There had been a hearing, 2 days of hearings, much of which the first day anyhow was kept under wraps. We just looked at a screen that said the court is in session, but you can't watch. And so a lot of people were very frustrated about that. But during the portions of that first day of hearings, a few little details leaked out. And even though it was a few days ago, it is maybe a week before we're recording this episode, some of the details that leaked out are worth reviewing. One of the things that came out in that hearing was that there was a bloody handprint on the handrail of the staircase inside 1122 King Road in Moscow, Idaho, allegedly that of a male. There was a glove outside with a body fluid. There were three. Now, this third bullet point we had known before, but it was mentioned again in this hearing. 3 unknown, untested samples inside the house. And what I thought was one of the major things that came out of that hearing was that the questions about Dylan Mortenson's credibility came to the forefront because she questioned herself whether her recollections were a dream. She admitted a bad memory. She admitted alcohol consumption. And frankly, a lot of people are wondering whether there's a lot more to that. One of the things about the secrecy in this case that I think it's something that has just become an addiction by all of the parties in the court. And the reason I say I think the secrecy has become an addiction is that when they came to arguing that part of the Franks hearing in which they were discussing Dylan Mortenson's statements about what happened that night, they would not allow her to mention the name of the witness. In other words, the court instructed the attorneys, do not use the names of the witnesses. Do not use the names of the witnesses. Just say the witness or the person that you spoke to. So Ann Taylor starts talking about it, and it became obvious to even a novice who might have read a newspaper headline that they were talking about Dylan Mortenson. So that's what I mean, that the secrecy in this case has just become an addiction. And those of us who are watching the case are just scratching our heads wondering, why? Doesn't that seem odd to you that they said that the court said that they weren't allowed to use the name of the witnesses, but then as soon as Ann Taylor started talking, it was obvious she was talking about Dylan Mortenson? Isn't that a little bit weird?
Well, the thing is, too, like we say witnesses, it's just like the whole world knows that we don't have that many options as to who could be a witness unless some mysterious dun 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 person is going to show up. But it, I think is almost kind of telling that she made it so clear on who she was talking about. I wonder almost if that's an indication that she doesn't necessarily want to keep things under wrap.
Now, there are a couple of little details that were talked about more openly than have ever been talked about in these hearings that were held in late January of 2025. One of them was, and I had forgotten this detail, that Moscow Police Department Detective Corporal Brett Payne, who, of course, wrote Exhibit A to the Probable Cause Affidavit, actually went to Pennsylvania the night that Bryan Kohberger's home was flashbanged, the doors broken in and the windows broken. He was actually there, Brett Payne was, and defense attorney Alyssa Massoth asked him about that.
Your arrival in Pennsylvania in time-wise to his arrest, time frame of his arrest.
I believe we arrived there if memory serves, about 7 p.m. on the 29th. And I think I get my dates right here. We observed final preparations for the SRT operation that was going to take place. And then we being myself and Detective Gilbertson from ISP, drove to a separate Pennsylvania State Police barracks to await the arrival of Mr. Kohberger.
Okay. And so he waited, he watched the special team, the special response team get ready, but he didn't go along on the raid. But as part of the defense motion to suppress, Jay Logston argued the way the Kohberger family home in Pennsylvania was bashed in was an overreach.
The point is that in this particular case, the state manufactured the exigencies, if they had them at all. The reality is, as they explain in their own affidavit, they're essentially watching Mr. Kohberger as he moves around his house via snipers. I mean, they were quite safe, and there was simply no reason to bash the doors in momentarily after yelling from their Bearcats.
Now, Judge Hippler, in fairness, did point out there were other issues, including safety of the officers and destruction of evidence. But I think there had to be a lot more going on. As we've discussed before, was there really any need for them to go into that house? Apparently, the law enforcement in Pennsylvania, the FBI and the Pennsylvania State Police, had tailed Mr. Kohberger. He would go out for runs. They saw him going into a drugstore. So I just don't buy that they had to go in the middle of the night. The judge does. The judge says, well, there was a potential destruction of evidence. There's the safety of officers. Makes no sense to me, because it would have been a lot easier for them to nab Mr. Kohberger in the middle of the day, like they did with the suspected Long Island serial killer, nabbing him in the middle of Manhattan in a day. But there's got to be more. There's got to be more behind all the secrecy in this case. Don't you think?
Well, there's got to be more behind the secrecy, but it makes me wonder if that secrecy is going to be lifted. So over here, we have this order regarding the January 23rd hearing transcript. So the court reporter assigned to the hearing in this matter on January 23rd, 2025 shall prepare a verbatim transcript of the portion of the hearing that was closed to the public. Upon completion of the transcript, the parties will have 14 days to identify those portions of the transcript that should be redacted from the public disclosure, providing a basis for the same. Thereafter, the court will release to the public a redacted transcript of the previously closed portion of the hearing. So it's like funny because it makes you want to be optimistic, but at the same time, it's going to be like the hearing that was just like private hearing in progress on for the first portion. It's like they're going to release the transcript, and what are we going to get? Is it all going to be blocked out? Do you think they're just going to leave it out?
Well, I mean, some of the stuff that I had mentioned at the top of this episode, the blood on the handrail, the glove outside, the DNA samples inside the house. I mean, what else? What else? I mean, this was the first time we heard about Dylan Mortensen giving a statement in which she questioned her own credibility, saying that, maybe she was dreaming, or admitting that she had used alcohol. And I know people have said that, you're vilifying the witness. No, we're analyzing the facts and the data and the potential testimony in this trial. And the real question I have is, well, what about Bethany Funk? What about Bethany Funk? We haven't really heard a whole lot about her, other than that there was an affidavit filed some time ago saying that she had exculpatory evidence. So just based on the couple of things that did, leak out from the hearings in late January of 2025, I'm just wondering what else there is. And so if a transcript is going to be released, it's subject to all of these redactions. So, I mean, I'm an advocate, I'm a follower of the JFK assassination, and, massive, massive, massive documents had been released over the years, but many of them are redacted. Many of them, they're so heavily redacted, they make no sense. And so is that what's going to happen here? I mean, one of the things in the Kennedy, I shouldn't even go back to that, but one of the things was Richard Helms of the CIA had been, asked, was Lee Harvey Oswald ever on the payroll of the CIA? The answer is redacted. So is this going to be like this? Should I be optimistic like I was way back in October when the court publicized a method by which people could apply to take a look at some of the secret documents? So I applied twice. I thought, oh, this is great. There's a process. They gave us a form. They gave us an email to send it to, and I did that twice. And twice my requests were rejected out of hand. So is this going to be another thing like that where we get our hopes up and, it's like Lucy and Charlie Brown and the football? Lucy says, okay, Charlie Brown, this is the year I'll let you kick the football. This is the year. And is this going to be another thing like that? I mean, I hate to reduce it to those terms, but that's what it reminds me of.
I mean, it feels, it's nice that they're almost entertaining the idea of it. But at the same time, it's just like we can't get our hopes up because they really haven't been open about anything so far, and they can't agree on anything. I mean, what even is going on with the experts right now? We don't even.
Well, yeah, remember that motion that Ann Taylor had brought some time ago saying that the prosecution had disclosed 25 experts, but they only had the backup data and the opinions and the reports of 5 of them, 5 of 25. So they're fighting about that. This is what we're allowed to see. They're fighting about that in open court. And Ashley Jennings had said, we've given them everything. We have complied with the discovery rule in Idaho, and we have also complied, Your Honor, with your scheduling order in this case. The judge wasn't really buying that argument, and he actually scolded, in my view. Ashley Jennings, you decide.
So let me give you a word of caution. Sometimes there's dissonance between what an expert thinks that they're going to talk about and what the lawyer understands from that expert. And the lawyer submits these disclosures.
Look how somber both Ashley Jennings and William Thompson look. Look how somber they look. And behind them is the Jeffrey Nye from the Attorney General's office. Don't they all look very somber that they're being scolded by the judge?
And, I think it's a very big scolding. I mean, I think because, we talk about all the tech stuff so much, and I don't know exactly, the dissonance that he's referring to between the experts and the lawyers in this case. But, it is very common. You don't fully understand what somebody is talking about in their own field. I'm very interested to know what exactly he's referring to here.
And I think it's really important that you be on the same page if you don't have a specific written report from the expert about what it is they're going to talk about, and make sure that you have supplemented and that you have provided a listing of the opinions that are going to be provided and whatever else is required under the rule in terms of what that's based on. And I would encourage both sides to over disclose those opinions in caution rather than under disclose. Because 2 things. One, you may find yourself in a bad position if you're not allowed to go into an opinion you felt you were going to be allowed to go to because it's not disclosed. And 2, I don't want to spend half our day at trial with me saying, where's that disclosed at? And then chasing the jury out while you dig through your thousands of pages trying to find where that is.
Feral.
Yeah. Yeah. And that's a good point because, a lot of times in trial, they stop and they send the jury out and they have all these arguments. And I don't know, if I were a juror, I would, why am I taking time off from my job and my personal life just to have the attorneys dig through all the stuff? And so to be fair, I think Judge Hippler has been stern with both sides. I think in all of the hearings, including the ones we're talking about now, he's been pretty rough on Ann Taylor. A couple of times he stumped her. A couple of times he asked her questions that kind of took her aback, and she had to kind of recalculate what her argument was going to be. So I think he's tough. I think he's fair. I think he's been equally tough on both sides. So people had always felt, and I don't know if I totally agree with them, but people always felt that Judge and Bill Thompson were just a little bit too close. They had a long history together, and people felt that the judge was really on the side of law enforcement before. I don't think that can fairly be said. I might be wrong, and if you disagree with me, tell me why. Don't call them names, because when you call these people names, we delete it. We don't like that. I'm a licensed attorney in only 2 states, but I can't be calling these people names, so you know what I'm talking about. So anyhow, oh, you're going to say something? I'm sorry.
I just have a question
Yeah.
because he says, like, how he's cautioning them both to over disclose. I was going to ask you, wouldn't that be considered best practice regardless? So isn't it like I don't know, so I'm wondering if this is a standout comment. Like, when you're putting out experts, don't you want to try to make them seem as
Seamless.
yeah.
Seamless. Yeah, no, that's a good point. I mean, I've been fortunate enough in the trial work that I've done. I felt that the judges were fair. If they were giving me a hard time, I don't like that. But if they're giving the other side a hard time at the same time, it's fair. If they're being, lenient with one side and hard on the other side, that's when you don't like it. But but dealing with experts can always be difficult. You prepare an expert. You must provide some kind of a report. You must provide some kind of notice to the other side under the Due Process Clause of the United States Constitution, no less under the rules of court here in Idaho. But any court, the states that I'm familiar with, have similar, not the same, but similar disclosure rules. It's pretty universal. You must disclose stuff in advance. And if the expert starts veering off course, as they often do, sometimes you ask somebody a question and you don't get an answer that, you're surprised by the answer. Well, if that happens in court, now you're going down the rabbit hole that the judge was just talking about. And I object. You didn't disclose this. You didn't disclose this opinion. I have the opinion that Mr. Kohberger did do it because objection. You can't talk about that. You've got to stick to the script. But so anyhow, the whole point of these hearings was one, motion to suppress. There were a dozen motions to suppress, but 2, a Franks hearing. And that's a serious matter. Should the court hold a Franks hearing? And the issues in the Franks hearing will be, did law enforcement make reckless misstatements of truth or outright lie? And as to whether or not the court will in fact grant the Franks hearing, I think the judge, and pay attention here, do you think the judge is hinted that he is leaning in the direction of giving a Franks hearing?
I don't know whether we're going to have a Franks hearing or not. I need to go and do that. But if you don't mind emailing some dates that you have available in the next, say, 3 weeks, to do that in the event that we need to do it, I would appreciate that.
Now
Okay.
that the judge is asking them to check their calendars and give him dates for a hearing, do you think that that's like a little bit of a hint that he's going to have the hearing, the Franks hearing?
I don't know. I mean, asking for the dates to have them, I hope not. I just, we want the case to hurry up, but doing these hearings takes a lot of time and resources. The fact that he's asking in the first place, it means it's on his mind, certainly, I'm sure.
Yeah, I would think so. Especially since these attorneys, at least Thompson and Ashley Jennings, and also the defense team, they come from up north. Boise's way down in the southern part of the state, and the others, have travel. They have travel expenses. They have to work their schedules. They have to, get babysitters or whatever.
I was going to say live their lives and see their families.
Yeah, so it just seems if in his mind he was going to deny the thing, why would he have given that little hint that, in the next couple of weeks, I want you to give me dates that you're available for this. But anyhow, so I do not know. I just think that it's interesting. I think that it's interesting that the judge has ordered the transcript to be given to both sides. but that both sides are going to be able to redact stuff. So, I mean, I don't know. I'm not going to get my hopes up like I did back in October when the court said, here's an application procedure to look at some of the sealed documents. No. And Lucy, if you tell me that I can kick the football and you won't take it away, no, I won't believe it.
That like my thought is like the transcript's gonna come out and it's just gonna be just bars over every single line. I'm not
I know.
optimistic.
Yeah, no, me neither. Yeah, me neither. Like I said, in the Kennedy assassination case, which I spent a fair amount of time looking into it, I actually I audited a college class on the whole thing. So much has been redacted. We've released documents. But now look at the pages and they're all black, and it's disgusting. So I'm just wondering, what are our commenters thinking about this whole mess?
Oh God, I mean, it's such clearness and transparency. You would assume that everybody's going to be very happy about all of this, right? This is the comments from one of our last videos on the Kohberger case. And this, is a sad comment. Don't be hating no one, anyone, I think. Anyone.
Love it. Don't be hating anyone. All right.
I can't believe they wouldn't let the families, and that's so sad. And that's how we're talking about that nobody was let into the hearing, and as even the victims' families, which I thought would almost always be allowed in.
Yeah, I would think so too. And there were so many empty seats in the courtroom, and it appeared that there was plenty of room. Or, if there were too many people, they could say, okay, only 4 people from each victim's family or something like that. It certainly would have been manageable. There's no question it would have been manageable. And if there were any outbursts, throw them out. Oh, Kelly Parker. How are more people not disturbed by this and other trials where governments are openly violating rights? That PCA was and is a joke. Like the entire case, the fact that everything's sealed is a dead giveaway of who's pulling the strings, and they aren't in Idaho. Well, all right. I don't know about that. I don't know about that. I'm just reading it. I'm not going to go as far as to say the PCA was and is a joke. I am going to say the actual Idaho PCA has never been disclosed. What we did see is the 18-page Exhibit A that was in fact authored by Brett Payne, who we saw testifying earlier in this episode. We have never seen the actual affidavit. And one of my applications for documents was for that. Only took them about 3 or 4 days to come back. Rejected. So that's as far as I'll go with that. Yeah. Rejected.
Right. Sandy Grog, can I just say that I don't really like Ann Taylor. All she does is, and we were giggling about this before, lay. We're thinking it's a lie. Maybe she doesn't want her client to go to trial. I don't get it. If the hearing is being streamed, why can't there be observers in the courtroom? The secrecy is just awful. Yeah, that's a good point. And as always, we're just reading the comments. We're not agreeing with them or disagreeing, especially with saying that people lie and stuff like that. But yeah, that's a great point. If we're seeing it on YouTube, why can't people be there in person?
Yeah, I've said before, I think Ann Taylor's doing a good job. She has a constitutional job. Her job rises to a level of, allowing and enforcing certain rights under the Bill of Rights. And Mr. Kohberger, no matter what you think of the allegations against him, is entitled under the 6th Amendment to a fair trial and a vigorous defense. And that's all she's doing. So what? She filed 12 motions to suppress. Are all 12 of them going to be allowed? No, of course not. I've talked about that before, so I'm not going to say anything else about it now. But I mean, she is doing her job, whether you like it or not. She has a job, and I think she's doing it fairly competently. Remember, if she doesn't bring all of these motions that a lot of people think are, superfluous, she's subject to a complaint for ineffective assistance of counsel. That's actually an appellate ground, but she's also subject to an ethical violation for not, zealously representing her client. So that's all I have to say about that. Oh, my turn. Oh, this is the Van Halen song, OU812. Remember that?
I don't know that song.
That's a Van Halen song, OU812. Anyhow, it seems the judge, I love musical people in our chat. It seems the judge was looking to Ann Taylor to go hard on privacy policies of companies and law enforcement breaking those policies. Feel like that is more important than Bryan Kohberger's privacy. The judge seemed to imply DNA was enough for a warrant, but if IgG isn't going to be used in court, what DNA was there? To people who think law enforcement can break the privacy policies for IgG to get their man, wait till you are denied health care or insurance because those companies use your IgG against you. Companies are watching these cases and taking notes. That's an interesting point. That's an
Mhm.
interesting point.
It's an interesting point, but I guess my thought with it is that we don't really know, and this is something that people have been arguing in the comments, is that whether or not like what these terms and conditions are, like the privacy policies, we don't know necessarily what we're, what was agreed to, what wasn't, um, and things of that nature. So, it is a fair concern to be concerned about what is happening with your data, but at the same time we're liking every single thing we see on Facebook and then posting all of our thoughts and opinions. So our biological data, hopefully isn't going to be held against us with insurance, but all of our data is out there.
The interesting thing I thought at the end of the 2 days of hearings towards the end of January 2025 was that the judge did say that he will be issuing a ruling on those motions to suppress forthcoming, which I took to mean pretty soon, and the IgG issue will be in there. So I'm looking forward to getting that order. And of course, we will talk about it here on this channel.
Mhm. So iBurns, and this again, we just read these. These are what people are saying. Steve G talks excessively, which is why they're not allowed in. Instead, they choose to taint the jury pool, raising questions about whether a fair trial is possible. These officers have been dishonest in other cases, so it makes the situation different. The fact that much of the evidence is suppressed should raise a red flag in itself. So I don't necessarily think that it's fair to pin this on Steve G specifically. And also, this is his life and his experience, and he has every right to relay his lived experience.
Absolutely. And I've said it before, people make these allegations, and we have some insiders in this and another case kind of following us. And I know because I get emails that tell us that people on the inside are following us, but they kind of hide behind these kind of nebulous, and I'm not saying this commenter is of that ilk, but people hide behind their little strange little email names or tags or whatever you call them. If there's someone on the inside of this case that wants to go on record and rebut some of the things like the last couple of sentences here, have at it. You know my email, it's down in the description, and we'll have you on in a New York second. That's all I'm going to say about that.
All right.
Oh, this
And
is mine. I'm sorry.
a related comment for you.
Angela 86753. If I were the G's, I would be furious with law enforcement right now, lying. There is no justice without truth and transparency. Okay. All right. I don't know.
Oh, yeah, a lot of people just want the transparency aspect of it. And for our last comment to show how fair and unbiased we are, which this not only did this make me laugh, but this person, that icon means they're subscribed to us. I just pulled these comments today. They've been subscribed to us at least since I'm assuming they've been subscribed to us for a while. Truth Nation Uncensored. Just when I think you're back on course, you go and do some idiotic piss poor segment like this. Bravo. I don't even know what we did to upset you that much. I don't think there's anything we could have done to win that situation. That's the YouTube comment section for you. It's just like
Now, which one was idiotic? Which one?
I don't know. The entire segment. This is a poor idiotic segment. The entire video, all our hard work. I'm sorry, the numbers are crashing. We hit what was it, 12,000 subscribers.
Yep.
We're in shambles. The content is absolutely in shambles, clearly.
You're probably getting tired of me telling the story about back when I used to be a TV reporter and we would drive around town with a logo splattered all over the vehicles that we would drive around town, and we get to a red light and people would pull down the window and say, "Yo!" So, I've heard worse. I've heard worse.
Yeah.
Hit me with
Andrew and I thankfully are used to saying some crazy, hearing some crazy angry people.
As Pat Benatar said, hit me with your best shot.
Yeah.
We don't mind positive and constructive criticism. We actually get ideas for future episodes from some of our commenters. So, if you want to take a low blow like this guy, fine. But, if you want to offer us some constructive criticism, that's fine. That's all right. I'm a big boy. I can take it.
Yeah. And this goes to show too, because you can't be mad. I mean, not to say that this person has ever been mad at us for this, but we try to leave most comments, even if they're not necessarily happy with us, when it starts involving other people, especially in local court systems. We have to be a little bit more mindful of that. But you guys are welcome to your opinions. I hope you guys know that we really do try to do our best to put these videos together in the best quality for you. And sometimes we may have differing opinions, and usually we're not even giving opinions. Usually we're just reading documents, and then you guys are inferring our biases one way or another, and then both sides are angry commenting us in the bottom. But
and we're looking for cases that people are interested in. People have mentioned some other cases, like Lainey, you were saying we should do more on Luigi. Someone else suggested that we should look at John Benet Ramsey. I mean, there's just so much that's out there. So let us know cases that you want us to do. And if we get more than 5 comments on any particular case, we will seriously, decide.
yeah, so I'm going to say, if you made it this far into the video, I think I've given you guys this one, comment a sun. And specifically, if you want a video on Luigi, comment a turtle. Because I saw some people, and comment a turtle and let us know. I don't know why I'm saying turtle. I'm just making up random emojis. But I saw people online saying what does this mean? What does this document mean? And all that stuff. So if you want us to try to just break down what's happening, let us know.
I wanted to close on the same note that we started on, that there's just so much in this case. Some of this we knew, some of this is brand new, and I'm just wondering, why don't they open stuff up so that we can, Dylan Mortensen, there are questions whether her recollections were a dream. She admits she had a bad memory, alcohol consumption. What else is in that ream of notes? I don't know if you saw all of those notes that Ian Taylor was reading through. Are we going to find out? Is the court order actually going to lead to the opening up of a transcript that lets us see what happened in there? I don't know. And my closing thought, as always, we have to remember that this case is about the 4 victims and their families, Madison Mogan, Kaylee Gonsalves, Ethan Chapin, and Xana Kernodle. And our hearts go out to the families of all 4 of those and all of their friends and coworkers and people that knew them. And we just have to end every episode to pointing out that, yes, we do know and we are aware that this whole case is about them. That's my closing thought. Do you have any?
No, I mean, you, as always, bring up a good point. This is, as much as we like to go back and forth, this is a real unfortunate case that involves the real lives of people, and to this day is impacting these people's families and more people beyond that. I mean, there's entire communities that are probably never going to recover for their lifetimes, But we appreciate you guys coming here. We appreciate that you guys, despite our poor segments, continue to watch us. We put love into this so that and all of these videos, there's a lot that goes on behind the scenes, and we're glad to have gotten to the point that we're at. So we appreciate you guys. Thank you.
And on that note, what do I always say?
Whether you are in the grocery store, the gas station, or anywhere else, please remember to be kind to people. You don't know what they're going through. And the same goes for our comment section. We want you to comment, but be nice, be kind, be positive if you can. And thank you for watching. Be sure to like and subscribe. Have a good one.